So we've had a whole series of change for the better in legislation because the sector has spoken out.
You're listening to Let's Imagine, an Imagine Canada podcast for everyone interested in social issues and the nonprofit sector. I'm your host, Bruce McDonald. At Imagine Canada, we believe that by leveraging our national vantage point, building cross-sector relationships, and sharing and developing our knowledge base, we can advance social, economic, and environmental justice through our collective action. Join us as we dive deep into conversations that have big implications for the nonprofit and charitable sector here in Canada. A special thank you to our knowledge partner, Carter's Professional Corporation, and our supporting partner, Sage Canada. Together, let's imagine a stronger future. To kick off the first season of our podcast, we want to chat about policy files from a legal perspective that will likely affect the nonprofit sector this year and possibly beyond. Normally, public policy moves at a very slow pace, but over the past few years, we've seen progress on a number of key files: political activities, the disbursement quota, and direction and control. Are these completed? What would possibly come next? To help us make sense of these and look ahead to the future, I'm excited to welcome our very first guest, Terry Carter, Managing Partner at Carter's Professional Corporation. As a charity and nonprofit lawyer, Terry has and still serves on numerous committees. He's a past member of the Advisory Committee on the Charitable Sector, a member of the Government Relations Committee of the Canadian Association of Gift Planners, and is involved with the Association of Fundraising Professionals, to name but a few. Terry, welcome. It's good to have you on the podcast.
So we're going to kick off with some thoughts around legal, legislative, and regulatory reform for charities and nonprofit organizations. Either moves at a glacial pace, or for long periods of time, it doesn't really move forward at all. With the Senate report being delivered in 2019 and the subsequent 3 reports from the Advisory Committee on the Charitable Sector, there are a wide variety of recommendations that could be seen as a blueprint for improvements in the operating environment for charities and nonprofits. Today, we want to talk about a few of these opportunities, those that are in play now, and your thoughts on what could come next. So we're going to start the conversation with changes to direction and control. The rules that govern how charities work with other organizations like nonprofits, collectives, etc. It's now known as qualifying disbursements. So Terry, what are your thoughts on the draft guidance that was circulated by CRA and is currently being reviewed?
Well, thanks, Bruce. And again, it's great to be with you, and compliments to Imagine Canada to move forward with the podcast series. I think it's a great idea. When we're looking at the draft guidance, which Canada Revenue Agency has put out for comments, I think, Bruce, it's first important to go back and look a little bit at the underlying legislation that came out in June of 2022. There are a couple of things that I think it's important for folks in the sector to be aware of. Number one, it was intended to be reflective of sort of the spirit of what Senator Omnivar had put forward with her draft legislation to eliminate own activities and direction and control. Well, we didn't get the elimination of own activities and direction and control. Instead, what the government put in place is an additional regime on top of the existing own activities and direction and control. So now you got 2 for the price of 1. And as a result, it's going to mean that charities are going to have to decide, do they want to do the old regime or do they want to do the new regime? And as a result, the guidance could do a bit of a better job in trying to explain why would you want to stay with own activities and direction control compared to moving over to the new regime of qualifying disbursements. Secondly, the concept of qualifying disbursements is it's a bit complicated when you start to drill down a bit. And I won't get into the complexities of it, but there's 2 aspects to qualifying disbursements. One is the concept of a gift. You make a gift over to another charity or a qualified donee, or you can make what's called otherwise making resources available, quote, to both qualified donees or non-qualified donees. And so if we just stop there, it's already going to be complex for charities to understand those two aspects. So I just got to point out that there are some complexities with the concept that's associated with it. And then the issue that I think will be of some concern for charities, not all, will be that only certain types of qualifying disbursements, Bruce, are going to count towards meeting the disbursement quota, not all. So you can't just look, Bruce, at qualifying disbursements in isolation. You also are going to have to take into account its impact on disbursement quota, and you'll need to keep the rules straight between the old regime and the new regime. And I think because of that, Bruce, some of the simplicity, which we were hoping would come out of the initiative that Senator Omnivar had put in place, some of that simplicity may be lost, and we may be picking up more complexity than we were looking for. That's, I think, some of the concern that I have. Not that Canada Revenue Agency is not trying their very best to come up with a guidance that's helpful, but what they're trying to do is make practical underlying legislation, which is complicated and which is going to create some additional challenges for the charitable sector.
And I think we'll also have to invite organizations to consider the draft guidance through the lens of, are they a grantor or a grant recipient? Because I think it also means different things to different types of organizations.
Absolutely. And, one of the objectives of putting forward changes to the Income Tax Act was to make the relationship between registered charities and non-registered charities simpler to work with without a lot of paperwork and documentation. But when you look at what's contained within the draft guidance, the type of documentation that's suggested there, it's kind of like direction and control light, right? As opposed to what we have with the own activities direction and control being the full scale aspect to that. So it may be that there's a lot of paperwork that still has to be done, Bruce, and that causes me some concern, not because the guidance isn't trying, it's trying, but the end result may still be a lot of work for charities.
That's great. Thanks, Terry. You noted both the QD and the DQ. So let's talk a little bit about the disbursement quota, that minimum amount that charities are required to spend, which I think for most operating charities is fine, but for foundations, it has a huge impact. So when we think about the changes to the disbursement quota that are coming into effect this year, what major shifts do you foresee for charities and nonprofits?
Well, the first thing is that there's now an increase in the disbursement quota, which is a statement of the obvious, but it's gone up from 3.5 to 5% above $1 million. So some charities like foundations will be asking questions, how do they meet their disbursement quota if they don't have any active charitable programs, if they're just transferring monies over to other charities? And that, Bruce, may bring up a question of foundations that have endowments. Does the charity need to encroach upon the capital of an endowment in order to meet their 5% disbursement quota? That could then require the charity to possibly get legal help and look at getting court authorization to be able to encroach on the capital. So that's the first thing, Bruce. I think that trying to meet the disbursement quota will have some complexities for some charities. A lot of charities, it won't make a difference to them, but for some charities, it will. Secondly, the legislation clearly now states that administration and management costs will not be counted towards meeting the disbursement quota. And so that brings up the question, what is administration and management, as well as how do you allocate between charitable programs and administration and management in order to determine what will be counted towards the disbursement quota? So a third thing dealing with the disbursement quota is the fact that making resources otherwise available will not be counted towards the disbursement quota. And that means that charities that want to make their facilities available to non-charities, or want to provide administrative support, or want to make maybe the use of their copyright or intellectual property, or want to have volunteers within their organizations available to non-charities, or if they want to have resources made available through microfinance. None of those will be counted towards the disbursement quota of the charity that is wanting to help out non-qualified donees. So I think that that's going to be an issue. And the fourth issue dealing with disbursement quota, Bruce, is there's going to be a lot more scrutiny, I think, given by Canada Revenue Agency, dealing with the importance of completing the T3010. A lot of charities haven't done a really great job of trying to track their disbursement quota compliance. And as a result, they often will leave certain aspects of the T3010 blank. That, I think, is going to be a bit of a problem on a go-forward basis. So I think charities are going to have to do a better job of completing their T3010. Why? Because the budget that came out in 2022 specifically stated that CRA would be given tools to review how the T3010 was being completed for the disbursement quota. So those are some additional thoughts, Bruce, on the disbursement quota issue.
I think obviously those are really important things for particularly foundations to think about. I think on the flip side, those who are service-oriented charities are pretty excited about the opportunity of having new dollars enter the system for foundations in particular who maybe weren't at the 5% threshold. So we've been talking about a couple of issues that are very much in the here and now. So let's turn our attention and look ahead. I'd mentioned at the outset, recommendations from the Senate report. We've had 3 reports from the Advisory Committee on the Charitable Sector that you and I have been part of. So there really are quite a number of recommendations for improving the legislative and regulatory environment for the sector. So from your perspective, in looking at all of these ideas, are there one or two that you would say are really game changers?
I think that there are 2 that I'd like to highlight that I think should be priorities for the sector. One is the importance of having a good, solid base of court decisions to help guide both the regulator and the charitable sector in what registered charities can do and can't do. Let me explain the problem. Right now, if you apply for charitable status or you go through an audit and you've got a decision from Canada Revenue Agency that you don't like, you didn't get charitable status, or you're going to lose charitable status, the options that you have now is you can go through an internal appeals process through the appeals branch. But if you're not successful at the appeals branch level, then your only option is to go to the Federal Court of Appeal. The Federal Court of Appeal is a body that looks at issues dealing with the interpretation of law, but it doesn't provide an opportunity for the charity to be able to have, in essence, what's called a trial de novo. It doesn't allow the charity to be able to question Canada Revenue Agency, to be able to cross-examine the officers involved in the particular decision. Instead, the Federal Court of Appeal is simply looking to see whether the decision from a legal standpoint was correct or not. So as a result, most appeals to the Federal Court of Appeal, in fact, almost all of them, over the years have not been in favor of charities because there hasn't been an opportunity to fully flesh out what needs to be looked at through a regular trial process. What the Advisory Committee of the Charitable Sector had recommended is that appeals should go to the Tax Court of Canada first before going to the Federal Court of Appeal. What would be the advantage of that? Well, there would be the ability for the charity to have a full trial on the issue, present evidence, be able to cross-examine Canada Revenue Agency, and get a decision that was properly considered through a regular tax court process. That, I think, Bruce, would allow the development of a real substantial body of law dealing with what charities can do and can't do. And so that would be first in my list, Bruce, of what would be helpful. If you like, I can give you a second one as well.
I think we're good on that for the moment. And I know that you and I have talked about this in the past, where law needs to evolve. And part of the way that evolution takes place is for it to be tested. And I think that was one of the reasons why we were thinking this is such an important change, to allow for more cases to come that would allow the law to be tested and therefore change and evolve over time. Again, we're going to talk a little bit about this public policy process. And, we've seen some changes to public policy in a relatively short period of time. So you've been working with this sector for, shall I say, a long period of time. And as someone who's witnessed progress or lack thereof during previous governments, what do you think's happening that is resulting in achieving some of these results that we're seeing now?
Well, I think what's happening is that the charitable sector is speaking out and becoming more engaged than they have in the past. What we used to do before is we would just kind of complain amongst ourselves. What's happening now is the sector is responding to situations on a collective basis in a coordinated way. Giving an example, back in 2012, we had difficulties with audits being done of environmental charities, and there was a real reaction from the sector to that. And as a result, when the current government came into place, the agenda of having audits of environmental charities came to an end, which was a good thing. More recently, there's been concern about the ability of charities to operate outside of Canada, in particular, also with Indigenous organizations, that would be devoid of having this paternalistic, patronizing approach of own activities and direction and control. And the Senator Omnivar, picked up that concern through the Senate Special Committee on the Charitable Sector, and as a result, led the charge to get involvement from the sector for the adoption through the Senate of her legislation dealing with Bill S-222 and then Bill S-216. So I think the answer to your question, Bruce, is we're seeing a reaction to the issues that the sector has because people are becoming engaged. Another example would be the change on political activities that arose out of the reaction to the audits of environmental charities. The legislation was changed in 2018. So we've had a whole series of change for the better in legislation because the sector has spoken out.
And I think you make a couple of great points here around the voice, the cohesion of sector leaders, in a sense, singing off the same song sheet, and also the unmistakable impact of having a champion like Senator Omnivar, someone on the inside who is willing to say, these are important issues and I'm going to work on them. So final question for our inaugural podcast. Since the beginning of every new year is a time of renewal and hope, what are you looking forward to in the coming year and beyond when thinking about the work you do with charities?
I would like to see charities being able to get on with the work that they want to do without being hampered by technical requirements which are limiting their ability to be able to move forward. Part of the reason, Bruce, that there was a big push for the elimination of own activities and direction and control was because charities were finding that they were encrusted with requirements and documentation that was necessary, and it made it difficult for them. So the approach that was taken was, let's make it simpler for charities to be able to do good. And that was sort of the motivation behind what Senator Omnivar did. I'm concerned that some of the new rules that are coming out, particularly dealing with qualifying disbursements, are going to make that a bit more difficult than I would like to see. So my objective and my hope for 2023 is that the regulator would continue to do good work, and they are doing good work, but would focus on trying to make things simpler for the charitable sector instead of more complicated. People want to get engaged, Bruce. They want to make a difference. But sometimes when they look to see all of the requirements that they have to get through, they give up and they don't want to participate, or they feel limited in all the things that they can do. We should be empowering the charitable sector, the nonprofit sector, to become more engaged. We need them within civil society. And as a result, the government and the regulators need to do whatever is possible in order to facilitate that objective.
Absolutely. I couldn't agree more. I think that we have a shared aspiration of saying, how can we work to remove barriers, technical, legislative, regulatory, to really unleash the power of social good in this country. And hopefully in 2023, we'll continue to make progress on some of the files that you mentioned and maybe other ones that we don't even know about yet. So with that, thanks so much, Terry. Really appreciate you taking the time to share your wisdom and your expertise, your in-depth knowledge of the legal environment in which our sector operates. And I know for those who are tuning in and listening, they've picked up some great insights, and we're looking forward to speaking again in the future.
Well, thank you, Bruce. My pleasure to be with you today, and great idea to do a podcast. I think this will be really encouraging for the sector, so good for you and good for Imagine Canada.
Thanks for listening to the Let's Imagine podcast. For full show notes and to subscribe to our newsletter so you never miss an episode, please visit our website, www.imaginecanada.ca. Also, if you really like this episode, we invite you to leave us a 5-star review wherever you listen to this podcast, as this helps other people discover us and engage in these conversations. And again, thanks to our sponsors, Carter's Professional Corporation and Sage Canada, for supporting our podcast.